Hi, everyone, and welcome. Thank you so much for having me. And I know that we're all gathered here because we are concerned Christians, and we want to be involved in the Great Commission that the Bible calls us to, and we want to be educated so that we can go out and speak truth in love. That's what the Bible calls us to. But before we can actually speak the truth, we first have to know what that truth is. So tonight I want to share some of that truth with you and give you some of the reasons and the legal bases that you can then go out and engage the secular community when we go out from here. And we can have answers for the hope that lies within us. We can have legal arguments that are also consistent with biblical truths. So let's get started here. Tonight I want to share with you a case for the biblical interpretation of constitutional law. We'll be doing three things tonight. First, I want to give you the tools to understand the U.S. Constitution in its lawful and its legal context. Those are two different terms in law that we're going to be talking about. Second, I want to give you the answers why any interpretation of the U.S. Constitution must be consistent with biblical truth. And finally, I want to show you how Christians must change the basis of our appeal in constitutional law and how we can engage other Christians, but also the secular community by changing our narrative. And what I mean by that is that when someone comes up to you and says, okay, well, you're a Christian, but I'm not, and I don't believe in that, and they have this relativistic moral worldview, then we can actually answer them and say, yes, but look at the evidence, look at our legal documents, look at some of the things out there that are objective, and we can actually engage them and have those answers. So we're going to be doing that tonight and answering these three things by looking at, first, the founders as lawyers. Often, if you've ever heard David Barton speak, and I'm a fan of Wall Builders, that's a really great ministry out there. Yeah. A lot of times we focus on the founders and them in a historical context and on their personal faith. But tonight I want to share with you another aspect that isn't actually talked about much, and that's the fact that nearly all of the most influential founders, with the exception of George Washington, were lawyers. They understood these legal concepts so that then when they gathered together and they wrote the Declaration of Independence as a legal document, the U.S. Constitution as the supreme law of the land, they used these legal terms that they understood and that they knew 250 years later, other lawyers could specifically understand what they were referring to and exactly what they articulated in those documents. So first, we're going to be going through a couple of the profiles of the founders as lawyers, and that's a really, really important thing to point out. Second, we'll be talking about the law itself. What do we mean when we say the law? That's a pretty general term. So we're going to be looking at defining the law itself and key fundamental legal concepts that will help you articulate a biblical worldview when you're discussing these critical issues today. And then finally, we'll be looking at the evidence, the founding documents themselves. We'll be looking at the actual text of the Declaration of Independence, the Federalist Papers, and the United Constitution as legal writings. And that's really important as well. So first, let's take a look at the founders. Again, all of the most prominent and influential founders, with the exception of George Washington, were lawyers, and they were educated with that legal background. The most important fact to this presentation is not whether the founders were Christians, but the fact that they were lawyers, and they were educated, and they articulated those legal concepts that 250 years later we can still understand. So first, Thomas Jefferson. He attended William and Mary College. He was admitted to the Virginia bar. He was the principal author of the Declaration and the primary drafter of the U.S. Constitution. He was a lawyer. Second, John Adams. He went to Harvard. He was admitted to the Massachusetts bar. He's probably the most recognized attorney from the Founding Fathers, and he assisted Jefferson during the draft of the Declaration. Again, he's another lawyer. Benjamin Franklin, University of Edinburgh and Oxford. He had an honorary doctor of law, even though he never practiced as a licensed attorney. He was educated on those legal concepts and understood legal terms. He was on the committee drafting the Declaration, and he also signed the U.S. Constitution. The Declaration Committee was comprised of 5 lawyers, the founders, Jefferson, Adams, Franklin, Sherman, and Livingston. The principal drafters were Jefferson and Adams. Again, the foundational Declaration Committee was comprised of these lawyers. When we look back in history and we think, wow, these founders really understood the role of government, they could see really far into the future and anticipate all of those things that might come up with the separation of the branches of government. The reason why they were so influential and they understood that is because they were lawyers. They were educated in this subject. So 5 lawyers that were the principal drafters and on the Declaration Committee. Alexander Hamilton, one of my personal favorites, and we'll be talking about one of his Federalist Papers in a little bit. He went to the King's College, which is now known as Columbia University. He was admitted to the Virginia Bar. He was the principal drafter of the United States Constitution and a principal author of the Federalist Papers. John Jay, he also went to King's College, now known as Columbia University, admitted to the New York Bar, a principal author of the Federalist Papers, and he was also the first Supreme Court Chief Justice, so obviously was a lawyer as well. And then James Madison, he was the 3rd principal drafter of the Federalist Papers. He went to Princeton University, and again, he studied law for public policy, and although he never practiced, he was certainly educated in these legal concepts. And he argued those legal concepts in the Federalist Papers and was also a principal drafter of the U.S. Constitution. So now that we've seen the profile of a lot of the most influential founders as lawyers, we can start understanding what they would have understood when we talk about the law. So what is the law when we talk about that concept? Law broadly is what's known as the concept of jurisprudence, or the study, the theory, the practice of the law. There are 2 different theories of law's origins. We're going to be talking about these, and these are really important for us to understand when we look at later the interpretation of the U.S. Constitution. The first is natural or divine law. The founders would have articulated this as natural law. Most of us have probably heard the term natural law before. I prefer to, again, change that narrative a little bit and use the term divine law because I think that that's more appropriate in today's society when we talk about that secular-sacred split and we talk about natural law can often just be referring to scientific evidence and that world of law that is only the physical universe. But when we talk about natural law in the context that the founders would have articulated it as, we're really speaking about divine law. And we are talking about the divine creator, the laws of nature and of nature's God. So divine law is actually a more appropriate term for what the founders would have understood as natural law. And we'll define divine law in just a moment. And the other theory is legal positivism, which comes out of a secular humanist worldview, and that's what's known as the social contract theory. And we're going to talk about what that means. So first, natural and divine law. The principles that underpin this concept as a theory of the law's origin are first that law is fixed. It's ordained by God, it comes from God himself, and is discovered by man. I put that in quotation marks for a reason, meaning it's not created by man. We simply see it in the world, we understand it, we label it, and then we practice within that universe that we are part of. So we can understand this in the context of our physical universe. We didn't create gravity. That was something that already pre-existed when man entered and was into the universe, and he started to understand the principles of physics. So gravity is something that existed. We simply discovered it. We figured out that it's there. We labeled it. We have to negotiate that as we go through our physical universe. In the exact same way, moral law is outside of man and is discovered by man. And we can see that in the general revelation of the universe to which we are presented and within which we exist. Because all of that physical law and metaphysical law, which includes morality, comes from God himself. It's fixed and ordained by God. So natural law then says that law has rational and objective limits to the power of legislative rules. If we go back to our example of gravity, we can see that it would be completely ridiculous for Congress to say, okay, Washington, D.C., we no longer want to be ruled by gravity, so we're going to impose a statute that says we're no longer bound by gravity. Well, we don't have the authority to do that, right? We may state that, but that's something that we understand is outside of man himself, and we don't have the authority to legislate that. And it's exactly the same with morality. Law itself, which includes the physical and the metaphysical, includes morality, has rational and objective limits to the power of legislative rules. God himself is the one that gives authority and enforcement to the law. So then there is inherent lawfulness with morality. And that's something where we tend to use those terms in everyday society interchangeably, legal and lawful, but those are actually two really different concepts in law. Legal means that it's something that is ordained by the civil government, like speeding limits. That's something that the civil government set up to say, okay, in this particular zone, you can only go 55 miles an hour. So if I break that, that's breaking a legal rule. Lawful is specifically outside of the civil government construct and that context and must adhere to morality. So when we talk about something being lawful, it means that it's in accordance with morality. So we can see that those are two very different things. So let's define the social contract theory as the second view or theory of law's origin. This is a theory that law is fluid. It's ordained by man and can be changed by man. What we mean by fluid is that it isn't fixed. It can change with the whim of a dominant society. Whatever the majority says, that's what happens. So it changes and it's molded according just to society. And that would include morality under the social contract theory. So law then has no inherent limits, only that which the legislature sets. So everything, both the lawful and the legal, are then determined by the civil government. And we can see how problematic that is. That's where we get the view of a relativistic morality, is the theory that law is fluid, and because the origin is man himself, we're free to state whatever we want in terms of the lawful and the legal. So then collective society itself gives the authority and the enforcement to law. There's no inherent lawfulness or unlawfulness. Everything is simply purely legal. This stems mainly from the philosopher Rousseau, who wrote the book on social contract theory. His idea was that man is essentially born free. We have no inherent morality outside of our world, and the only reason that government exists is because we naturally have to interact with each other, and so then, as a collective society, we have to determine what rules, what morality, what enforcement we want to give to the law because we have to interact with each other. So then there's no inherent lawfulness or unlawfulness, nothing that's right and wrong. Everything is simply purely legal. And we can see the seminal example of this and the problem with this worldview is shown in the example of Nazi Germany. So when Hitler ordained his government on the premise of everything being purely legal, no inherent morality, it was legal to annihilate the Jews. But we can see in the greater context of the world and of these fixed objective principles, that was absolutely not lawful. So today, a great example of that would be the abortion debate. That might be legal today in our society, unfortunately, but it's absolutely not lawful and not in accordance with morality. So I'm an attorney. I like charts. This will help you kind of see the difference between divine law and social contract theory. When we talk about its origin, its rationale, meaning the reason for it, the authority, enforcement, and then finally the interpretation of the law itself. So under divine law, the origin of law is God. Everything comes from in the beginning God. That fundamental principle and precept then sets the stage for everything else, and everything is built upon that premise that God himself, as a fixed author who is unchanging throughout all of human history, no matter the culture, the governments that rise and fall, he is fixed, unchanging, and he himself provides the origin of our laws. The social contract theory says that the origin is man. We are free, again, to engage in any type of law that we want, and we set the parameters because the origin of law is just within man himself. So then the rationale for divine law becomes fixed, objective, because God himself as the origin never changes. Social contract theory says that it's fluid and subjective, because if the origin is man, man changes. The authority under divine law is God's sovereignty. He holds the universe together, and he also decides when to affect his sovereignty, and we can see his working throughout human history under his sovereignty. And we'll talk about authority a little bit in more detail in just a moment. Under the social contract theory, the authority is simply man's agreement. We go in together, we have the power of contracting, and so when man comes together and he agrees, then that's really what gives the authority. So the enforcement under divine law is moral law and God's supremacy. We know that God is the supreme judge of the universe, and his supremacy is what gives moral law its enforcement authority. Contrast that with the social contract theory. The enforcement is codified law, or the statutes and the principles and the judicial opinions that we have, and man's power of force, the majority. We've seen that today where all of us collectively, even if we all come together under social contract theory and think that we have that equitable bargaining power, Rousseau himself even saw that the ultimate conclusion of that worldview is totalitarianism, where the majority force wins. And so eventually collective society is represented by what he terms the sovereign. And right now in our society, our sovereign really is the Supreme Court. The majority of those 9 justices are man's power of force. Okay, so when we get to the interpretation of laws under divine law, they must be consistent with biblical truth. If we understand that the origin of all law is under divine law and it's God himself, fixed, objective, then it absolutely has to be consistent with biblical truth. And so when we look at civil society as enforcing some of those rules, and when we have the power of the civil society coming together, that's still under divine law. And so any interpretation of law must be consistent with biblical truth. The social contract theory, on the other hand, says that the interpretation are changing to the whims of a dominant society. The majority wins. And whatever majority wants to say today may not be the same tomorrow, so it's fluid and it changes to the whim of whoever is in power. So with these 2 different theories, completely different theories of law's origin, the question naturally becomes, the United States, are we a divine law or social contract state? And that's really the basis of our appeal and how we need to change that narrative when we're talking to other people and engaging them in the debate. People presume that we're a social contract theory state, right? We have a relativistic moral worldview. If I believe in the Bible, someone else doesn't, that's okay, because everyone needs to tolerate everyone else. But the United States, was that built on divine law or social contract? In order to determine that, we're going to actually look at the founding legal documents. See, where did we get our source of authority? Was it divine law or was it the social contract theory? We'll look at the Declaration of Independence. We will see through the text itself of the Declaration that the authority that the founders as lawyers appealed to directly was in divine law, and they specifically stated that. And the legitimacy for the United States to become a sovereign nation was specifically rooted in divine law, not the social contract theory. We'll look at the Federalist Papers as the rationale for the new government. Once the founders, as lawyers, had properly understood and had said through the Declaration the proper role of government with its roots in divine law, then the founders had to come together and say, okay, so what does a legitimate government look like? When we understand the proper role of government, how can this actually play out in our new society? So we'll look at the Federalist Papers, and then finally we'll look at the U.S. Constitution itself, and we'll understand that not only in its historical context, but in its context as a legal document and built upon this understanding of the legitimate authority in divine law. So again, I really like charts. This is my founding documents hierarchy, and this is a visual representation of how we can understand where to place the United States Constitution in context, not only in history 250 years ago, but also within the context of the legal basis for its authority over us. And we're going to see that the authority is in divine law, and the legitimacy of that authority is specifically stated in the Declaration of Independence. So legitimacy, that's another term that is a legal term that the founders understood. What do we mean by legitimate authority? Legitimacy in the law means lawfulness and inherent authority by virtue of being authorized or in accordance with truth, conforming with a valid, rightful, and appropriate authority. We can see this concept played out when we look at some of the other ways that there are sources of legitimate authority and also illegitimate authority. If I walk into court and I say, Judge, I want you to decide this case based on this authority that I'm citing to you. If that's not a legitimate authority, then he's going to tell me, counsel, that's not an adequate source of authority, and I don't have to be bound by that because that is not legitimate. So we'll see that the founders understood that concept of legitimate authority, and their appeal was specifically and directly to the only source of legitimate authority that conforms with valid, rightful, appropriate authority in accordance with truth, and that is divine law with its origin in God himself. So again, we need to remember the difference. Lawful means in accordance with morality, and legal simply means in accordance with civil law. So the founding of America began with the Declaration of Independence as a legal document. Divine law says that there is a legitimate authority for new government through our rights that transcend king, man, government. Those unalienable rights that the origin of which is from God himself. That's in contrast to the social contract theory, which would have been an illegitimate source of authority for rebellion against the established government. So the Declaration of Independence provided our legitimacy and authority to become a sovereign nation. The Declaration specifically stated, our rights are unalienable and come from God himself. He is the origin of our rights. So therefore, our rights pre-exist the United States Constitution. This is a concept that has gotten so confused in today's society. We think that our rights stem from just the Constitution. That's not true. The founders recognized and expressly stated that our rights come from God and pre-exist the Constitution. So then the only purpose of government is to protect those God-given rights. That is the sole legitimate role of government in any society. And then the founders understood when government usurps our God-given rights, it's not only one of those rights of the people, but then it becomes our duty to abolish that government and restructure it according to our legitimate authority in divine law. Notice the founders specifically did not say, as we go through the text of the Constitution, they didn't say, we come together under our own power and authority and agreement to enter into a new contract together because we have our own power and ability and authority to do that as free men. That's not actually what happened. They understood that the only source of legitimate authority to become a sovereign nation was a direct appeal to God himself and natural law, or what we should be saying, divine law. So the Declaration then legitimized, again, it was legitimate authority, the independence of the United States to separate from England, and asserted divine rights. These included legal rights, the right and the duty of separation and revolution. It included those legal rights that are found within the government, but it included the moral rights and those things that are inherently lawful because they come from God and they're greater than the scope of the government. They realized that government is only legitimate and only has proper authority when it operates solely to protect our God-given rights and works in accordance with divine law. So the Declaration justified the independence of the United States by listing the colonial grievances against King George III and the way that he was usurping those God-given rights, and by asserting certain natural and legal rights, including a right of revolution, and to restructure the government only according to its legitimate and proper role. So let's look at the text of the Declaration itself. Hopefully we're all familiar with this, but it's so amazing. When you look at it, it is right there. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. That is a specific, direct appeal to divine law authority. A decent respect to the opinion of mankind requires that they should declare the causes which impel them to separation. Notice this is so different from the social contract theory. Specifically stated in the Declaration, the laws of nature and of nature's God that entitle us. We hold these truths to be self-evident, discoverable, out greater than man. We hold these truths to be self-evident that all men are created equal and endowed or given by their creator. The origin was the creator, God himself, with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. This was the declaration of the founders. Again, as lawyers, they understood they had to declare a legitimate authority for what they were doing. And those founder lawyers, the 5 of them on that declaration committee, specifically stated that they understood that the proper legal appeal was to the origin of divine law truth and God himself. So the Declaration specifically goes back to divine unalienable rights. And we've talked about this a little bit in the context of legal rights versus lawful. And they're 2 separate and different types of rights. Legal rights are those bestowed onto a person by a given legal system or government by virtue of being under that government's proper role and authority. An example of that might be a driver's license. The government issues a driver's license, and that's a legal right that the government gives you. But if you go out and commit certain type of driving offenses, DUIs, driving under restraint, that kind of thing, then the government can take away that benefit or that right that it bestowed upon you because the government is the origin of that right. That's very different from the unalienable rights that the founders specifically referred to. Divine unalienable rights are not contingent upon the laws, customs, beliefs of any particular culture or government. It is outside of the time and space of a particular government and are therefore universal, coming from God himself, and are unalienable. So the Declaration goes on to state that to secure these unalienable rights, governments are instituted among men, deriving their just powers from consent of the governed. Right here, the founders are saying this is what we understand and we recognize with our appeal to legitimate authority in divine law. The only proper role of government is to secure the unalienable rights that were given to us by God himself. and that whenever any form of government becomes destructive of that end, destructive of securing our unalienable rights, it then becomes the right of the people to abolish it and to restructure our government so that we can make sure that its only proper role is to secure our rights. Then it ends, we, therefore, the representatives of the United States of America in General Congress assembled, appealing to who? Their legitimate source of authority, appealing to the supreme judge of the world for the rectitude of our intention. These lawyers know who their real authority is, right? They called God the supreme judge of the world for the rectitude of our intention. Rectitude is an old English word that means morally correct behavior or thinking, righteousness, lawfulness. They appealed to God as their legitimate authority to separate from England and said, we appeal to the supreme judge of the universe to know that our intention is to appeal to that divine law authority to restructure government to its proper role, which is to secure our unalienable rights that come from God himself. This is all right there in the text of the Declaration of Independence. And these 5 lawyers on that Declaration Committee knew exactly how to set that down so that 250 years later, we could go back, we could see that, and we could read it for ourselves and know exactly to whose authority those lawyers were appealing to. And for support of this declaration, with firm reliance on protection of divine providence, again, that enforcement authority, God's sovereignty and his providence, we mutually pledge our lives, our fortunes, and our sacred honor. These 5 lawyers knew exactly to whom they were appealing. So the Declaration is a direct appeal to divine law. To recap, we said in the Declaration, the laws of nature and of nature's God. That is divine law. The origin of government comes from God himself for our United States. The rationale, then, for law is fixed, objective, universal morality, unalienable rights from God himself. The authority for the establishment of our nation, not the social contract theory, but God's sovereignty. Enforcement, moral law, and God's supremacy, and our duty as the consent of the governed. So then, interpretation of civil law. This is the basis of our appeal, is that our interpretation of any civil law that has to be consistent with biblical truth, because that is the only proper role of any government of the United States. So the founding documents hierarchy then, we can see that the direct appeal to the authority was in divine law, and that legitimacy was declared through the Declaration of Independence, which was a legal document. We know that it's a legal document because it had a legal effect. It's the difference between a marriage license and a love letter, right? Both of those things might express the same love and affection and the intention of 2 people to be married. But a love letter is simply that writing that states that. It doesn't have any practical legal effect, where a marriage license as a legal document has the effect of taking 2 people and bringing them together, and then they are married. So the Declaration of Independence, we know, is a legal document. It was written by 5 lawyers, so it's definitely going to be legal. But it also brought about a legal change and a legal outcome, which was the separation from England and forming a new sovereignty. So that appeal to legitimate authority is absolutely in divine law. So now that the founders as lawyers all understood that their basis of appeal, and they set down specifically in the Declaration that the appeal to legitimate authority was in divine law, then they had the problem of, well, how do we restructure our government? Now that we have this new country and we have the great privilege of shaping a country where the proper role of government is solely and exclusively to preserve unalienable rights, what does that look like? So the Federalist Papers and also other contemporary documents and the Constitutional Convention itself, those were all documents that we can go back and we can look at basically what is a legislative history or an insight into how the founders actually came up with our system of government, the executive, the legislative, and the judicial branch. So arguably, when we have this proper role of government, that can look several different ways. We have two houses in Congress, the Senate and the House. Well, if there were a third one, would that necessarily be inconsistent with divine law? No. So the founders understood that the proper role of government was simply to secure our unalienable rights. So then, like lawyers do, they argued among themselves, what's the best way to secure our unalienable rights through the proper role of government? So the Federalist Papers give us insight into how they structured our government. This is the rationale for the U.S. Constitution. So let's look at some of the Federalist Papers. What were they? There are 85 articles and essays that were authored by Alexander Hamilton, James Madison, and John Jay, 3 lawyers. They promoted the ratification of the U.S. Constitution, and they show the rationale for the supreme civil law that eventually becomes the United States Constitution. So number 84 by Hamilton is key, and this is why when I mentioned earlier he's one of my favorite founding fathers, this is exactly why. Hamilton argued that it's unnecessary and dangerous to add a Bill of Rights to the Constitution. He said we don't need to set those down. Why? He was concerned that the future government leadership, maybe 250 years later, could then say that our rights, because they were textually listed in the Constitution, the government leadership could then say that those rights were given by the government. So then the government has the authority to take them away. That was his concern. And rather than being unalienable and being divine rights that supersede the government leadership would say, we gave you those because they're in the Constitution, so we can take them away. We can change them. So let's look at the actual text of this. Hamilton wrote, Bills of rights, in the sense and extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous, affording a colorable pretext to claim more government restrictions on our God-given rights. What is a colorable pretext? That's another legal term that Hamilton would have understood. A pretext is a motive or a purpose alleged in order to hide the real purpose or reason for doing something. Colorable is a plausible legal claim. So it's a claim that's strong enough that if it had a reasonable basis of possibly being valid, if it's generally correct. So a colorable pretext then would be a plausible purpose or motive. So if we go back to Hamilton's text, he said bills of rights are dangerous because they might afford this plausible pretext or this seemingly valid reason for doing something when really the subversive purpose is something else, to claim more government restrictions on our God-given rights. He was really concerned about that. So then he goes on to say in Federalist 84, for why declare that things shall not be done in which there is no power to do? Why should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions should be imposed? If you insert any other unalienable right, the right to life, the right for traditional marriage, all of those biblical principles, if you insert that into this statement instead of liberty of the press, Hamilton's concern is saying, why should we declare things in a Bill of Rights that the government will then have this plausible pretext to go and usurp those things and say, we gave you those rights, when there's really no power to do that? I will not contend that such a provision or a Bill of Rights would confer a regulating power, but it is evident that it would furnish to men disposed to usurp our unalienable rights a plausible pretense for claiming that power. And we see that's exactly what's happening today. And Hamilton was really concerned about that. So if we go back to the founding documents hierarchy, we can see that divine law, again, is the source of authority. The Declaration provided the legitimacy to become a sovereign nation because it appealed to divine law's proper, valid, rightful authority. The Federalist Papers were part of what we call the primary sources, or those debates among the founders, again, most of them lawyers, who understood that there needs to be a reason for structuring the government in the way that we did in order to have it fill its proper role, which was to preserve our unalienable rights. So then, built upon the authority of divine law, the legitimacy of the Declaration, the rationale of the Federalist Papers and the primary sources, we then get the U.S. Constitution. What is that? That is the supreme law of the land that, again, is at the top of this pyramid because it has its roots all the way back down into divine law. And we have to understand the U.S. Constitution in its lawful and its legal context, which is this hierarchy. So when you talk about the U.S. Constitution, it's the supreme civil law of the United States. It is only the law. It's simply the nuts and bolts for how the framers and the founders, as lawyers, decided to structure our government according to the sole legitimate role of government and divine law authority. It was framed by 55 delegates to the Constitutional Convention, and it is a legal document. Why? It provided the supreme law of the land. It had a practical legal effect. 32 of the signers to the Constitution were lawyers. They understood exactly what these provisions meant. They also understood that the sole purpose of the United States Constitution is to preserve unalienable rights under the legitimacy of the Declaration and God's vested inherent authority in government to structure itself in accordance with divine law. So then what do lawyers mean when we talk about constitutional law? What is that? Well, constitutional law is the body of law that interprets the Constitution and the written text. It forms the judicial case law and precedent from the written text of the federal Constitution. That's all that constitutional law is. It is not itself in any way able to redefine or restructure the Constitution as the supreme law of the land. If we look at Article 3 in the United States Constitution, that's the article that gives the judiciary its role, its scope, its authority, which is specifically under the Constitution. So the primary and only purpose of the judiciary is to make sure that the legislature and the executive branch are enacting laws that are in accordance with the Constitution at the top of that pyramid, that is in accordance ultimately with divine law and that rightful authority. So the legitimacy for the Constitution comes from the Declaration. The authority, remember, comes from God and divine law, not judges. And that is something we don't even teach in our law schools anymore. Unfortunately, when I was going through law school, we started out with the very first Supreme Court case, Marbury v. Madison. That's where we start in law schools, is to start teaching that the Supreme Court has the power of what's called judicial review, or the ability to review those laws and see if they're in accordance with the Constitution. That's true, but we have to first start with the origin of law, the authority, the Declaration, the rationale, and then the Constitution to understand how do we interpret that. It's not in a vacuum. It's in accordance with its rightful, legitimate authority in divine law. So legitimacy comes from the Declaration and God himself in divine law, not judges, not constitutional law. That's simply the interpretation to make sure that all of the laws that interpret the U.S. Constitution are still in accordance with that founding document hierarchy, and they are consistent with biblical truth, with specific revelation and general revelation, in accordance with everything we know to be true, because everything comes from where? In the beginning, God. So the text of the Constitution and civil law cannot be interpreted in a vacuum. It cannot be divorced from the rationale and the authority of the Declaration and the foundation in divine law. So lawyers have two theories of constitutional interpretation. The first one is judicial activism. We'll see that this root is in the social contract theory, and it's rulings on constitutional law cases that are based on political considerations, majority force, the current whim of morality in the dominant society, fluid interpretation, and subjective meaning. That is obviously inconsistent with divine law. So the second theory of constitutional interpretation is judicial restraint. This is the idea that constitutional interpretation and rulings on constitutional law are based on limited judicial power fixed, objective interpretation, and legislative intent, going back to the only proper role of government, which is to secure our unalienable rights. And every ruling on constitutional law has to be in accordance with divine law truth, which are also biblical principles. So we have the founding documents hierarchy. And so what happened? Because obviously our Supreme Court is a judicial activist court, right? We're no longer practicing judicial restraint. We're no longer in a society that understands that our only source of legitimate authority is in divine law. So what happened? Well, our Supreme Court very, very cunningly and systematically sought to draw a line right here in our hierarchy and take the Constitution as the supreme law of the land off of that pyramid, separate it from its proper roots and its legitimate authority, and place it onto a judicial activist hierarchy. That's what happened. So now our U.S. Constitution is divorced from truth and from its source of legitimate authority, and we have placed it onto a social contract theory foundation. So now we have no legitimate authority. And so our Constitution has become civil law that's completely divorced from morality. And we're saying that our Constitution can be interpreted based on social contract theory, models, and principles, which ultimately have their roots in a secular humanist worldview. And that's what our Supreme Court has systematically done and has educated our society to say our Constitution's premise is in the social contract theory, it means whatever we want it to mean. So then we place our Supreme Court on top of a judicial activist hierarchy, and the interpretation of law becomes interpretation based on a secular humanist foundation. We need to go back to a judicial restraint hierarchy. We have to understand the authority is in divine law. The legitimacy comes from the Declaration of Independence because we appeal to the supreme judge of the universe, God himself, as the origin of all law. The rationale for our system of government was found in the Federalist Papers and those contemporary documents and primary sources that ultimately ratified the supreme law of the land. So then, in its proper role and context, when the Supreme Court sits on top of this pyramid, we can see that if the Supreme Court derives its only just legitimate authority, it's only going to have interpretation of the U.S. Constitution based on a moral foundation. It has absolutely no legitimate authority to exercise its power of judicial review apart from a judicial restraint hierarchy, because the only source of authority is God himself in divine law. Our Supreme Court has completely obfuscated that fact and is trying to sell us on the idea of a judicial activist hierarchy. And that is so scary. So interpreting the U.S. Constitution, when we interpret that, our authority for government is in the Declaration and under divine law. This is the legal basis of our appeal. We have to be talking about the root and the foundation of our only legitimate authority. We can't approach constitutional law and constitutional debates from a social contract theory perspective. We can't engage the debate like that. Otherwise, we will have already lost, because we're simply saying if we're in the minority, we lose. My opinion is no more valid than anyone else's opinion, because we are missing the fact that the only legitimate source of authority is found in the Declaration, which specifically appealed to divine law. So then when it comes to interpreting the U.S. Constitution, it starts out, and I love this, I love the Constitution, we the people of the United States. This is generally where anyone talking about Constitution will start. They will take this out of context, out of that hierarchy, and say, we start with we the people, so that means we're free to interpret it however we want, right? No, that just means that we the people, within that context of legitimate authority that has already been stated by the founder lawyers, are saying that we the people of the United States, because we understand this proper role of government, in order to form a more perfect union, establish justice, a principle of divine law. Justice is a moral concept. Ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. Secure the blessings of liberty. To ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Thus, when we say that our rights come from the Constitution, we're in effect agreeing that our submission of our rights are to the whim of federal judges. We have to articulate and understand that our rights are unalienable and they come from God himself. So unfortunately, we do have a Bill of Rights, fortunately or unfortunately. Hamilton was ultimately not successful in having his fears really taken seriously, and Madison argued for a Bill of Rights, and the first 10 amendments to the United States Constitution are what's known as the Bill of Rights. And those simply set down certain unalienable rights that the founders, given the time and place in history and what they had been dealing with in England, were specifically wanted to say, this is an unalienable right. We recognize that. But if you go back and you look at the proper role of government, the appeal to the legitimacy of divine law, they understood that they weren't setting this down in the Constitution to say our government is giving these rights. They were saying we are recognizing that these are unalienable rights. Among these are life, liberty, and pursuit of happiness. There are many more that come from God himself. So then consider how the different foundation, divine law versus social contract theory, will ultimately change the outcome of all these critical issues that are facing the church, Christians, and ultimately American society today. Abortion, marriage and divorce, same-sex marriage, privacy, education, God and society, and government itself. Consider if we were truly a society that still understood that we have to act in a judicial restraint hierarchy, consider how all of these critical issues would change if we understood that our only source of legitimate authority is in God's law himself and in a biblical interpretation of the Constitution. So how was the Supreme Court successful in doing this and in taking the Constitution off of its foundation and trying to sell us on the social contract theory? It started initially, one of the cases was Everson versus Board of Education. We're going to go kind of quickly through this because I do want to leave some time for questions and answers. So Everson versus Board of Education specifically stated, in the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. Because that was articulated specifically in a Supreme Court decision, we now are under the assumption that the term separation of churches and state appears in the Constitution and is a constitutional concept. It's not. I would encourage all of you to go back and read the letter to the Danbury Church, which is where Jefferson was writing, and see that in context, and in context with all of the founding documents and in that hierarchy. Jefferson wasn't advocating for the separation of church and state in the way that we took that out. We've all been in sermons and under church messages that have taken specific passages out of the Bible and then built their own doctrine around it, right? And we all as Christians understand why that's so problematic. That's exactly what the Supreme Court does with different constitutional concepts. They take them out of the Constitution, so yes, those words appear, but that's not actually the appropriate doctrine. And here, the separation of church and state doesn't even appear anywhere in the Constitution. So then the next really critical case was Griswold v. Connecticut in 1965. This case was primarily because of the sexual revolution and how the feminist agenda and all of these things were working together with different secular-based philosophies that was advocating for the free expression of sexuality outside of the confines of the biblical marriage and biblical terms for sex, and wanted to advocate for sexual freedom. Well, the judges who decided Griswold v. Connecticut knew that there's no way that that's actually constitutional in order to have free sexual expression. So the vast penumbra was created. This was a legal fiction by a group of really smart judges who understood that a lot of people would not understand the legal terms. And so they created what is actually taught in law schools these days as fact. The penumbra appears nowhere in the Constitution. That's actually a scientific term that originally meant the space between the light, or the fuzzy zone, a transition period. Literally reading between the lines. That's what the penumbra is. And so Griswold v. Connecticut stated, well, there's a penumbra in the Constitution. We are going to read between the lines and see these rights to contraception, to women's choice over her body, all of these things that are absolutely nowhere in the Constitution, because they know those are rights that are against biblical principles, so they're not rights at all. They're simply something that, as a social contract theory, they wanted to create to further that agenda. So they created this term of the vast penumbra. And if we go back and we look at every subsequent decision that furthered the sexual revolution, it refers to the penumbra of the Constitution. So Peanuts is one of my favorite comics, and we can see Lucy looking at her book, and she goes, I give up, there's no use trying. No matter how hard I try, I can't read between the lines. She's right, you shouldn't. So I wish our Supreme Court would take Lucy's word for it. So then we have Lemon v. Kurtzman in 1971. This redefined freedom of religion in the First Amendment to hold that any government action must have a secular purpose, must not have the primary effect of advancing or inhibiting religion, and must not have excessive entanglement with religion. It went along with the Everson versus Board of Education decision that erected that high wall of separation between church and state, and this is still the case that attorneys have to argue when we go into court and we talk about religious freedom. The Supreme Court in 1971, under a judicial activist theory, said we're going to redefine freedom of religion. But we know now they're not free to do that. But that was a very, very cunning and subtle way to try to erect that wall. So then, furthering the sexual revolution, we had Roe v. Wade in 1973, arguing from the premise of a social contract theory is direct democracy, whoever gets the popular vote. So judicial activism redefined life. We're not free to do that. God is the origin of all life. God says that life begins at conception. God values life, all human life. We're made in God's image, all of those biblical principles. But judicial activism ignored moral law concerning abortions. And this cartoon here is particularly relevant because we're approaching the debate as Christians head to head. And that's really the social contract theory model. We're saying that if we just force our view and we can argue it, then that should be majority force. And the moral majority is one of the things that we're trying to reclaim. It doesn't matter, ladies and gentlemen, if there's one Christian or if we are a nation filled with Christians who understand this concept. Truth is truth. Truth is fixed and objective. We have to argue from our only source of legitimate authority in divine law and not approach the table allowing them to change this and pervert that hierarchy to say that it's my opinion versus yours, pro-life versus pro-choice. We have to change the basis of our appeal. So then we get to Lawrence v. Texas in 2003. This was the Texas law that criminalized sodomy, and it was overturned. Judicial activism, again, ignored the immorality of homosexuality. This case appealed to the vast penumbra, and it found the right to privacy and sexual expression within the penumbra of the Constitution, literally reading between the lines. Then Orden v. Perry. This is a case that I like to include in here because sometimes as Christians we think the outcome of a decision is more important than the rationale or the reasoning. And we have to be really careful when we look at how the Supreme Court is slowly undermining religious freedom and is relegating that to a historical context, because Van Orden v. Perry was the case of the 10 Commandments that were erected on the grounds of the Texas State Capitol, and they said, okay, you can leave that, but that wasn't really a win for us. They specifically said that the 10 Commandments conveyed a historic and social meaning rather than an intrusive religious endorsement. We can't allow truth to be confined to a historic meaning. Truth is alive and active today. So we have to be really careful when we celebrate some of these decisions. So finally, we get to redefining marriage. That's been the latest thing as of June of this year. Even back last year, February 14th of 2014, a Virginia judge called upholding traditional marriage a violation of the 14th Amendment's Equal Protection Clause. Again, took that amendment entirely out of context, referred to the vast penumbra, and Judge Wright Allen said, our Constitution declares that all men are created equal. Well, no, that's actually a term in the Declaration. The judge should maybe go back and read that. But she's saying our Constitution, surely that means all of us, right? So what was the Christian's response to that, or the moral majority? Well, Virginia House Speaker, who's a Republican, responded to that and said Virginia's marriage amendment was duly adopted by the legislature and ratified by an overwhelming majority. He was appealing to the social contract theory. That's absolutely not true. And even though it's true that the marriage amendment was duly ratified and adopted, the basis of the appeal should not be the moral majority. It should be that we have fixed objective truth and our legitimate authority in divine law. So then we get to Obergefell v. Hodges, June of this year. Same-sex marriage was declared constitutional through the penumbra, this right to privacy, that's the right to sexual expression, and the right to marriage that's found under the 14th Amendment's Equal Protection Clause, again, taken entirely out of context. This has become civil law divorced from morality. What is now legal is certainly not lawful. So we all saw the rainbow flags, and then this, if you're on Facebook or Twitter, you saw this hashtag love is love, and everyone was saying how great this was. And even though they're saying that this is simply a right, really it's an appeal to change and pervert morality. Justice Kennedy in his decision said they ask for equal dignity in the eyes of the law. Well, equal dignity for what? For freedom of any form of sexual expression. That is absolutely not lawful. So the consequences of redefining marriage. Basically what this did was allowed for state licensing of same-sex marriage. Importantly, it did not yet impose restrictions on churches or faith-based organizations or First Amendment privileges, but that's where we're headed. And we can certainly see that in a lot of the things that are current events that are going on with a lot of these clerks and even the bakers, the photographers in my own backyard in Colorado. That's all going on. So that's really important to understand that the churches need to stand and declare for truth right now, so that when those attacks come, we can say, no, this is our unalienable right vested in God's legitimate authority. So redefining marriage, this has been the progression of the sexual agenda, and it's setting the stage for polyamory, bestiality, and eventually pedophilia. When we start redefining life, when we start redefining what love is love, well then my freedom of sexual expression should then be allowed in any manner whatsoever. And I can see that happening in cases further down the road that will advocate for the legalness of pedophilia. Once we redefine personhood, that's become another debate of redefining when life starts, when abortions are able to happen, partial birth abortion. That's going to start becoming more and more after birth even. And then when we define when personhood attaches, which we're not free to do at all, but when we as an amoral civil government start saying we can redefine when personhood attaches, what if we decide that children don't attain personhood until the age of 18? Well, then suddenly the pedophile has no victim. And they're saying love is love, and I am able, it's my right to freely sexually express myself in any manner that I choose, including on a child. And that's where we are headed if we do not stop this and if we are not educating ourselves on the legal basis for a divine law morality. And so, ladies and gentlemen, we need to change the basis of our appeal. We can't enter into the debate not understanding the social contract theory, not understanding that our rights are unalienable. They come from God and his divine law, that our rights pre-existed the United States Constitution, that constitutional law cannot be separated from moral law. Majority is not the issue. Truth is the issue. Truth is always the issue and will always be the issue. Government and constitutional law are only legitimate when in accordance with divine law and God's authority. So true patriotism, and I love this country. I am so proud to be an American. But we have to understand that true patriotism is not just coming back into our churches, but going out and being actively engaged in the civil government as Christians, relating these principles, not only educating society and our children, but also being engaged in our civil government so that we can go out and restructure it again to conform with the only proper role of government, which is to secure our unalienable rights. So true patriotism is advocating for divine law and the legal foundation of our founding documents. So I'm going to leave you with this, Romans 13:1. Let every soul be subject to the government authorities, for there is no authority except from God, and the authorities that exist are appointed by God. So please feel free to contact me. This is my personal email address. I'm also on jennaellis.org. Thank you so much for being here tonight and for engaging in this conversation, and I really appreciate your time.